happened to me. On this deployment I didn't want to go on, turned out to be a tremendously good thing for me, unintended consequences, because it really made me reaffirm what's most important to me, and that's my relationship with my family. I'll be honest with you, my wife and I are very close, but my 9 months away from her made me even closer to her, and I felt like a lot of people, I was scripting my life. I was just following through the footsteps, just putting one foot in front of the other. A lot of you married. You know, when you're in a relationship, you start to put one foot in front of the other, and then all of a sudden 20 years goes by, and you realize, holy moly, I've been married a long time. And so it gave me a chance to get a newfound perspective on my relationship. So ironically, it's the best gift I've gotten during Christmas, to have a better sense of these relationships. I hope you find a little bit of that at the end of the year as well, and get a chance, I know you're super busy, to reflect on what's most important in your lives. That really is what it's all about at the end of the day. So, thank you for supporting me. I got a ton of support from the city while I was gone. In fact, it almost seemed like you were thankful I was gone. So I'm going to take it to the high road there and interpret it well. Let's talk about work. I got a ton to talk about. This is my world right up here. In fact, obviously the far left, you can't talk about work without talking about weapons at work. I want to have a candid conversation about that. The events of last week in San Bernardino, ironically, a government workplace, which is afflicted once again by workplace violence, is by far and away the hottest topic of the most recent events, followed previously to that week to the events down in Colorado Springs. So every employee has a ton of questions about what is the best mechanism for organizations to make themselves safer in the workplace. I've got a few highlights about that. When it comes to employment law principles, you got to know them. And I have to tell you, most importantly, when it really comes to the issue of workplace violence, it's all about communication with me. Period. In coworker on coworker threats, and we're still going to find out as they deconstruct the events in San Bernardino, but in coworker, and again, it's a different kind of violence last week, an ideological bent to it, but it was still coworker on coworker violence. In my experience, 100% of those cases have been preceded by some form of threat. So I'll be curious if we find that in this particular case, because that's what we need to know about. Are people making threatening comments with regard to their own workplace? That individual, most likely, as you could probably are well aware, their employment security upon making a threat is non-existent. Most employees get terminated nowadays for making threatening behaviors or comments. Moving over across the top of that is the issue of e-cigarettes and vaping devices. I have a lot of questions from employees about that. What is our prerogative to address this? You probably realize Colorado, that's why we do these employment law classes, is to put them in context. Most supervisors in Colorado know that we are unique in that we have a state law provision that says you cannot hold it against an employee. They're off-duty, off-premises legal conduct. So can people use e-cigarettes and vaping devices in their own time? Certainly. But do employers have the right to regulate those devices within the workplace? They do. And now the question is, are you doing that? Because people have expectations about their use, and I see them with frequent use. Which goes across the top to, that's the employee who's working on the beach, and that is, where does work end and where does our personal life begin? This has come up a lot with a hot topic from this past year, and that is, do we have to accommodate an employee? And I want you to ask about this. Do we have to accommodate an employee by allowing them to work from home? Why that's interesting is that more and more employers, because of work-life balance issues, have telecommuting policies, which are a foothold for people to ask for what? More time at home in order to work from there. Thankfully, you all work in public sector employment. Is there some responsibility on the part of every employee to have interaction with a supervisor and have interaction with members of the public? Does that potentially limit the ability to work from home? It does. Over across there, FMLA, ADA, workers' comp, we have to talk about it. That intersection comes up every time. Hopefully we'll have a good conversation. This is an area in which I'm finding that more supervisors are coming to me, and I'm not trying to be negative, but they're coming to me with hard questions about the fear that their employees are abusing this privilege, the ability to take time off under the FMLA, and how do they better manage it. I also read in this morning's newspaper, this duty to accommodate is very strong. I read with interest, and you probably don't read the newspaper, especially the sports page, in as much detail as I do, but if you read today's Denver Post, I discovered, and I'm a huge football fan, that former University of Southern California football coach Steve Sarkisian just sued the University of Southern California in violation of the ADA. He alleges he's disabled, being an alcoholic, and was not accommodated by his university. You might remember in the middle of the season he was fired summarily because he was hammered on the job, and they immediately removed him from his position. So that case is, once again, can any person avail themselves of the ADA to try to generate some level of accommodation in the organization? Which goes to, of course, around the corner. You can't really tell from that bottom part on the right-hand side of the slide. That is actually a graph of the most recent number of states that have medical and recreational marijuana provisions. It's hard to see, but the lighter green there, the lighter shaded green, are medical marijuana states, and the very darker shaded green, Alaska, Oregon, Washington, and Colorado, those are recreational marijuana jurisdictions. So are a lot more jurisdictions creating rights for persons who use medical or recreational marijuana. That's a big deal here because our Supreme Court finally ruled on whether employers can regulate medical and, by extension, recreational marijuana in the workplace. You might know that answer pretty well. Which goes around the corner. Paid parental leave is a hot topic. There is no requirement yet under state law to provide paid parental leave. But interestingly enough, is this a hot topic? Are more and more employers considering paid parental leave rights? And are more states mandating a paid parental leave benefit? You know what's supercharging that is these other countries around the world. We are the last bastion of a westernized country that doesn't offer some type of paid parental leave. A lot of you know this. The FMLA is an unpaid benefit, but you can use your accrued paid leave benefits towards it. This is the next salvo in this trend, is a paid leave benefit as part of being a new mother or a new father. We'll talk about that as a bunch of legal questions with regard to that. More and more employers are getting into this. Going up around the corner, that's a pregnant employee. You can't tell necessarily, but that's a pregnant employee in the far left. We're going to talk a ton about this. You can't talk about the law of the workplace this year without talking about the Supreme Court's look at pregnancy and pregnancy rights. Kind of a confusing decision on the part of the Supreme Court, but there's some golden nuggets for us. I still maintain perhaps the most protected person in America is the employee who has a serious health condition under the FMLA and has a disability under the ADA. But interestingly enough, a pregnant employee is now perhaps just as equally protected in this country given newfound Supreme Court guidance in this area. Just above that is religion at work. We've got to talk a little bit about this. A lot of misconceptions in this area. I'll talk more in detail about it because this is an area where the federal government is really asserting its influence. Bar none. It is their priority issue. And I'll be frank, well, I'll save that for our discussion, but this is a hot topic. There is no way to look at it other than a hot topic, and you got to know a ton about it in these types of sessions. And then finally, in the very middle of that is, you're probably well aware of this, and I'm going to give my editorial comment about it. I have never seen a more quick expansion of rights in this country. And I'm not making this as a negative or positive statement. This is a neutral statement. I have personally never seen a greater expansion of rights in this country than the rights associated with somebody's gender identity and sexual orientation. It is phenomenal. And in fact, one of the reasons why we have these programs is for you to understand the rapid shift with regard to this particular extension of rights. And it is almost, in my mind, dizzying to try to keep up with this protection. And some of these protections may surprise you in terms of the extent to which they go. In particular, with regard to the use of the restroom and the use of locker room or changing facilities when it comes to someone's gender identity. So I want to prepare you for that. It's subject to good discussion, and nobody can really not learn something in this area. So you guys up for the challenge? You feel, I know at least 2/3 of the people in the room personally, you would feel very comfortable asking questions. That's really what we want this to be, and I appreciate the chance to do it. So let's go through it pretty quickly. Those are my hot topics. I mentioned nearly every one of them. I'll talk a little bit about wellness programs and where that's gone. Have to talk about the issue of violence. We're going to talk about overtime. That's a big deal. The federal government wants to change the rules surrounding exempt status. They've already proposed to do so. The the $50,000 question is, when do those rules go into effect, if they ever go into effect? But it's going to change the complexion of who is exempt and not exempt in this country. And then finally, retaliation. We'll get to that in just a moment. So last year, some of these slides only takes me 30 seconds to talk about. They really are just to generate discussion. So ironically, it's ironic for me because I do this for a living, and you may not care an iota, but ironically for me, while the current administration of the federal government has a very strong regulatory bent with regard to employee rights, the EEOC is at the height of its powers. The Equal Employment Opportunity Commission is literally at the height of its powers. But ironically, the number of allegations of discrimination in the United States has actually gone down every year of the current administration. So from 2007 all the way to present, the number of EEOC charges has declined rapidly. So we were up close to 100,000 back in 2007, and now this last year we're at 88,000. I just saw, you remember the federal government's fiscal year ended on September 30th, so I just saw the numbers coming in for this last year, and while it went up a little bit, it's still under 90,000 charges. This is considered to be remarkable that while more and more people are in the workplace, the number of charges is decreasing. It could be for a variety of reasons. Maybe these good enforcement efforts are part of it, but it is a distinct trend that fewer people are raising charges of discrimination. Does that let us off the hook? Probably not, but interestingly enough, few people are complaining. Why do I put this slide up here, though? You know where all the action is. It's one of the reasons why you're here. All the action, with all due respect to all the protected categories, 42%, actually 43% of charges allege retaliation. So now we're approaching a half of all federal discrimination charges have an element of retaliation. You need to know this to be a manager. Have you figured this out, that basically where all the battle lies as far as effectively managing employees is it pretty easy for people to lay claim to, you're retaliating against me? And is that going to get the interest of the federal government? So I'm going to give you some advice about this relatively quickly. Number one, and I'm not trying to be conspiratorial, it's pretty easy for people who feel as though they're not being managed effectively to lay claim to these civil rights allegations. I feel as though I'm being mistreated. With the protocols you have in place, do we effectively investigate those claims? We do. Is that something we should encourage the city to do? Of course. But where you're exposed, and Karen, jump in here if you think I'm speaking out of turn, but where you're exposed is after someone complains, some appearance of retaliatory or reprisal treatment against them. So you got to know, once again, who's the most protected person in America? The person who complains of an underlying civil rights violation and you somehow treating them differently after they've complained. Would you please be mindful of that? It really pays huge dividends for the city that we avoid the appearance that somehow you've treated someone differently because they complained. In fact, you know what I encourage? You shouldn't be the one doing the investigation. You shouldn't be the one involving yourself in the investigation. That should be through another arm of the city, including external resources, to leave you free to manage the individual. You know what the quick fix on this is? We've talked about it a bunch. You got to remember when you go to these classes, I think the only two things that supervisors really do manage, you lead people, but you manage performance and behavior. And that's it. You don't manage somebody's personal religious beliefs. You don't manage somebody's claim of inequity. You don't manage somebody's personal life. You manage their performance expectations you set for them, and you manage the behavioral expectations you have for them in the organization. And if you can objectively show that you're doing that, will you survive any effort of someone to challenge your managerial responsibility over another human being? I would say yes. So please remember that. You manage performance, you manage behaviors, but you don't manage necessarily someone's private life, the fact that they may not necessarily look or act just like you. Does that follow? That's the quick get-out-of-jail-free card. Now, what's interesting to me is Texas gets the most charges of discrimination. I only put it in there because it's personally satisfying to me, because I'm from Colorado. I have no idea why it's relevant to this class, other than it's interesting to me. So we're not Texas, and once again, I say to myself, thank God we're not Texas. And it just reinforces my own personal beliefs and bias. So, next thing. Hey, I wanted to do what the EEOC's lawyers think is important, because it's what I think is important, and quite frankly, it's what you should think is important, because that's where the government's really looking to assert their influence over us, the federal government at least. So let me run through these relatively quickly. You cannot talk about civil rights in this country without making it very clear that issues of race are always at the forefront of the EEOC's consideration. So racial harassment's number 10 for them. It's always in the top 10. And of course, you need to be aware of that, because the Civil Rights Act of 1964 would not exist but for the issue of the fight against racial discrimination in this country. So it's still out there. Use of background screening and hiring, or the so-called ban the box movement. Has anybody in the room ever heard of this concept of ban the box? This is a huge topic, and that's one of the reasons I want you to be smarter than every other employee in America. You will hear this. It'll be in the newspaper. You're going to hear it a lot, and you're going to hear it a lot in the last year of President Obama's administration, because he's already made efforts to try to address this issue. So ban the box, if you're unfamiliar with this concept, is the nationwide effort to ban that box in the employment application that asks, have you ever been convicted of a crime? The theory behind it is there a form of discrimination based on the fact that somebody's been arrested or convicted of a crime? And the federal government believes, and you can disagree with them, the federal government believes there is rampant discrimination on the basis of color against persons, that's race and ethnicity. So rampant discrimination against persons of color based on their race or ethnicity because they've been arrested or convicted of a crime. And you probably know the demographics of that. In the United States, more persons who are black and more persons who are Hispanic are arrested and convicted for crimes in the United States. So this is an effort on the part of the federal government to protect people who are swept up into our criminal justice system. Now, please do not lose sleep over this. Is it still lawful for the city to inquire into somebody's criminal background if it's related to their job? And do we still do so? And will we likely continue to do so? Yeah, I mean, you got to know, there's a tension here, but ironically, do a lot of employees of the city work with vulnerable members of the population, whether it's youth, whether it's elderly, whether it's persons who might be harmed by others. And so is that incumbent upon us to look at somebody's fitness to do those types of jobs? I will tell you, again, we do these classes relatively quickly, but I think there's three things about somebody's past that are always relevant to the city in terms of their criminal behavior, whether they're arrested or convicted. If someone was I had a case in which somebody was literally arrested, was convicted of murder 30 years ago, as an 18-year-old, was in a barroom brawl and killed somebody. That's sad. I have to tell you, though, 30 years ago, they had actually done their time. It was manslaughter. A person fell after they were hit and hit their head and died. But they did their time. They went to jail. They had constructed a life in which they were a good employee for the remainder of those 30 years. Do you think that person poses a risk of harm now, 30 years later? Probably not. And so I want to be one of those people who is very clear. There is much room for forgiveness in this area. But I also want to be frank. The three areas that I'm most concerned about that you need to consider for somebody you're considering for employment are, not surprisingly, areas of violence. If someone's been convicted of a crime of violence, is that relevant to their employment at the city of Commerce City? Yes. Number two, most of our employees have access to public funds, public equipment, public property, and the public trust. Therefore, if someone's been convicted of a crime of dishonesty, larceny, theft, would that be relevant to the city of Commerce City? Absolutely. And third, and of course this is always problematic, is issues associated with drugs and alcohol. If you have a job in which you drive or have a safety-sensitive job, is it always relevant to us about your fitness to do those things because of a past history of drugs and or alcohol? Relevant? So please keep those in mind. Those would potentially affect employment.
What about sexual crimes?
Sex crimes are going to be very much relevant. I put those in the category of crimes of violence. And so sex crime is invariably a crime of violence perpetrated against another, often without someone's consent. And so interestingly enough, that would be in the category of very much related, especially for what you do, and that is people work in the recreational services. It's always relevant. Someone who has access to a locker room, a place of privacy, a child, vulnerable, a disabled person who might be frequenting a recreational facility. Is it always relevant that we find out someone who's engaged in a crime involving a sex-related offense? It's going to be the case because you know these circumstances happen where people who are vulnerable might be preyed upon sexually by predators. Okay, good stuff.
What about go back to alcohol and drug conviction? Couldn't that be claimed as an ADA accommodation?
Yeah.
Could be charged with discrimination for failure to hire somebody?
You have to tell you what's amazing. The question, you didn't hear it. This is why I like coming here. The question is, wait a minute, what about someone who's had prior, drug or alcohol history? Couldn't they argue, even if they were convicted, that they are protected under the ADA? And there's a rule about it. And that's why I love your question. Here's the rule, is current alcohol and drug use is not protected. So please be mindful of that. Someone who has currently misusing alcohol, a DUI you got last week, the fact that you got discovered using cocaine and were arrested using that, none of those things is protected under the ADA. The rule about past drug use goes like this. Recovered alcoholics and recovered drug abusers are protected under the ADA, but you're not protected based on the crimes you committed for being under the influence of alcohol or drugs. So I can't hold it against somebody who applies for a job who's a recovered alcoholic. I can hold the fact they had 3 DUIs against them in the past and view them as unfit to operate a motor vehicle. Does that make sense? That's an awesome question. And I like it. Are there a lot of people who have recovered from drug and alcohol problems, and do they have ADA protection? People need to know that, so don't rush to judgment. It's the behaviors that against them and their qualifications to do a job here, not the fact that they recovered from drug and alcohol abuse. That's an excellent question. Okay, let's keep going. Down this list, discrimination in hiring. You probably heard about this case. I hope you have. EEOC is suing Bass Pro Shops because they are believed to have a pattern and practice of discriminating against persons who are black and Hispanic, and they're not hiring them in the hiring process. So they're currently fighting this challenge to see a pattern of not hiring persons of color within the organization. Next down that list, retaliation is, of course, a hot topic. I mentioned 43% of all federal cases involve this allegation. Immigrant, migrant, or vulnerable workers, that's a hot topic of the federal government. As please keep in mind, and you don't need to know a ton about this, but the basic rule is this. Vulnerable workers or immigrant workers or migrant workers, the typical recipe here is they're persons who are immigrants. And I will say, the federal government is of the opinion that even unlawful workers still have protections under federal law. They may not get damages associated with harm inflicted against them because they're not lawfully in the country in the first place, but can the employer be punished for preying on a vulnerable population, hiring unauthorized workers? But in this case that I have up here, Global Horizons, this is a massive lawsuit, primarily in the Pacific Northwest. Global Horizons runs massive farm operations, and they purposely hire, in this case, Thai workers, Thai lawful immigrants to the United States. in most of whom don't speak English as their first language, and they were subjected to horrific employment terms and conditions, and the EEOC has rooted out this employer and is attacking them for preying on persons who are relatively new to the country and are vulnerable because they don't understand all the rights associated with working in the United States. So please remember that. Of course, I also want you to remember the rule. Does every person have to demonstrate they're authorized to work in the United States to work for the City of Commerce City? They have to do that ideally within 3 days. There are some exceptions for people who have temporary work authorization documents, but you have to show work authorization in the United States within 3 days. What is the prerogative of Commerce City to do if someone can't show work authorization? Terminate them, and I want to emphasize that word. It is lawful to fire someone in the United States that doesn't show proof of work authorization, which is an identity document, valid identity document, and a work authorization document. What's the most commonly given work authorization document in this country? Very good, Social Security card. Can an employee be required prior to hire to give a Social Security card? No. Are there other work authorization documents? Yeah, if you have a passport, you have both U.S. passport. You have U.S. work authorization and your identity. When someone's hired, though, can we require them to show a valid Social Security number and card? Yes. Please keep that in mind. Questions on that? Okay, you guys are good on this stuff. Moving down the list, ADA, talked a little bit about it. We're going to come back to it, especially working at home. LGBT rights, again, going to be a big part of our conversation. Pregnancy, another big part of our conversation. And I don't want to talk much about conciliation rights. You'll see it come up here. But basically, you should know the federal government has a responsibility to try to settle claims. It's called conciliation. They haven't been very good about allowing employers to do it. And this past year, and you don't need to know this, the U.S. Supreme Court slapped down the EEOC because they weren't giving employers fair opportunity to conciliate effectively, to try to resolve claims without going to a lawsuit. And so now the EEOC is under a heightened scrutiny that they have to allow employers to reconcile claims of discrimination. That's really more on the legal side of the house than on the management side of the house. And then finally, hey, I want to ask you this question. You don't have to get this right. According to the EEOC, their number one priority is religious accommodation. Of all the problems in the world, why do you think that would be their number one on their list? You really can't get this wrong. Why do you think that'd be their number one? I have my own theory. I think it's this. You always go with your best horse. It's one area where they have unquestionably won almost every case. And so if you want to go with your best, what's your best priority? Is that which you have the most likelihood of success? That's this one. And I want to prove it to you. The big news here is this EEOC versus Abercrombie and Fitch case. This was big news this past year, and it's by far and away the greatest victory of the EEOC in the last year. It's also the greatest vulnerability of employers in the last year. So in this case, it's an interesting case. You will never screw this up, but it does raise an important question about what are the responsibilities of managers. So here's what happens. Ms. Eloff shows up at Abercrombie and Fitch applying for a job. I have never been in an Abercrombie & Fitch. I do not have washboard abs. I cannot even wade through the smell of Axe cologne. So I feel like this is an impenetrable location for me to even try to enter. But young Ms. Eloff applies for a job at Abercrombie & Fitch to be a retail salesperson, and she shows up for the interview wearing the hijab, which is depicted here, the traditional headscarf worn by Muslim women. Now, the interesting thing about this is there is little or no discussion in the interview about the fact that she's wearing this hijab. I think there's an offhand remark about this, but no discussion of the fact that she's Muslim, the fact that she's wearing a hijab, and even more importantly, and this is critical, there's no discussion about the fact that Abercrombie & Fitch has this, a look policy. It's a dress code. They call it a look policy, in which they're looking for people who really can typify their brand. So not young, but people who can wear their product and can wear their product well. Because their salespersons are also what? Models of their brand. And so you wear Abercrombie when you're selling the product. And so interestingly enough, she ends up not getting the job. And she knows something's up, and she challenged this decision because she otherwise meets all the qualifications. And it comes out in the litigation that they didn't hire her because she doesn't meet their look requirement. What's interesting about this case, and it's fascinating to me, is at the lower courts, Abercrombie & Fitch won. The theory was this: hey, it's not our job to ask everybody what their religious beliefs are. She never said she was Muslim. She never requested an accommodation. She could have just been wearing a what? Headscarf. And so she never really asked for any accommodation. Therefore, we have no duty to extend an accommodation. The second defense they had was even more clever, which is this: we're not discriminating against any religion. Our policy, part of our look policy, is you cannot wear headgear. You cannot wear caps, headgear, while you work at Abercrombie. So the fact that she wants to wear headgear, it doesn't matter that she's Muslim and is doing this because of her religion. Nobody gets to wear headgear if they work at Abercrombie. That's a neutral, non-discriminatory reason for not hiring her. What do you think of those defenses? They're terrible. The Supreme Court, 9-0, and would you agree our Supreme Court is a relatively contentious body? 9-0, the Supreme Court says, seriously? No way. I mean, it's almost like ignoring the elephant in the room. There is no discussion whatsoever. Could you reasonably have identified that she was wearing this headgear because of her religious beliefs? And therefore, they have to have asked her, we have a no cap policy. Can you abide by this? And of course, even more fundamentally, and you got to know this one rule. It's the only thing you got to know about this case. It's the most important principle associated with this case and why the EEOC won. Even if we had a neutral, no headwear policy, do we still have to accommodate somebody's religion? Yeah. Religion trumps dress code, but I know there's a lot of smart people in here. With what exception? Very good. That's why I love coming here. Except for work safety is religion trumps dress code up to the point of an undue hardship on the organization, which principally is going to be a safety concern about wearing this gear. Does that make sense? So you got to know this rule. Could someone who, think of every iteration of this. Could someone literally on the first day of work ask for an accommodation even though it never came up in their interview? Could they say the minute after they're hired, I wanted to tell you, I do have these religious beliefs that require me to, kill small farm animals periodically throughout the day, and I'd like time to do that during the course of the day. Instead of you saying, what? Shut up, get back to work. Are you going to have to consider an accommodation for that individual if it's based on a religious need? So I don't care what they're saying, is there a potential accommodation? And you know what the other point here is? You can't try to mask this. Was it fairly obvious that this person was wearing the religious headscarf because of her religious beliefs? So can we say these are the essential functions of the job? Can you meet the essential functions of the job with or without religious accommodation? And so you can't literally ignore this issue when it comes to work. Does that follow? This case is an easy win for the EEOC in my estimation, regardless of what the lower court said. So please remember that. Don't ignore someone's religious rights in the workplace. Gets even better because, interestingly enough, here's where the debate's difficult for me. So I don't know if you read about this case. This case, are any of you on Facebook? This case actually was a Facebook headline. I saw it on the day this occurred, and it was couched this way. The first line, Muslim truck drivers fired for refusing to transport alcohol awarded $240,000. So Muslim truck drivers won't transport alcohol, win $250,000. And I will tell you why my job and why your life is made difficult. I think there are people working to make hay out of these cases to support their own political agenda. And I want to make sure you're smarter than what you read on Facebook. So how this was couched in my Facebook world was, this is Sharia law. This is the changing nature of working in America, that this is how we're having to put up with an intrusion of another religion in a world in which no religion can be ascended in the United States. And I have to tell you, that is an incorrect statement. I think that statement was made solely to generate misinformation and discontent. And I'll tell you why. When you read about this case, it has nothing to do with Sharia law. So here's what happens. These truck drivers, they work for Star Transport. They have a dispatch function where the next load comes up, you got to take the next load. It comes up for these two guys that the next load happens to be alcohol, and they raise objections. I don't want to transport alcohol. That begs for what discussion? Why? A dialogue. And I also have to tell you what frustrates me about this case. This is what I worry about in this country, that people are cowed by not understanding their legal rights. Because here's the thing. With all due respect, like I mentioned back here, these cases beg for a respectful dialogue. Please don't kill the messenger here. But when two people tell me they can't deliver alcohol, you know what my response would be? Why not? Well, my religious beliefs dictate it. What religious beliefs? Again, I'm not Muslim. I'm not trying to offend anybody. I'm not asking these drivers to consume alcohol. I'm not asking them to encourage other people to consume alcohol. I'm not asking them to serve alcohol. This is a packaged product that I'm solely asking them to deliver. I'm not a theologian, but I struggle to see how this would violate anyone's prohibition on the consumption or use of alcohol. Do you think that's overstating something? Do you think I'm talking out of turn? I'm just religiously ignorant in this. I don't understand a faith that would say you literally cannot, you're not even asked to touch this product. We'll load it, you move it, and you don't even have to touch alcohol with your bare hands. So do you think that's a religious affront to somebody? I have no idea. But do you think that's a reasonable question that could be asked of any employee in America? Does that sound rude or cruel? All I'm asking for is an answer to that question. And I think it's reasonable. But even more fundamentally, to get back to this case, they'd allowed all kinds of other drivers to be accommodated when they didn't want to take a shift. So if a woman was pregnant and the load was too heavy, she could be accommodated. If somebody felt the product was dangerous, they could opt out of it. So they had accommodated people to not run loads. They didn't enforce a forced dispatch policy, which says what? I don't care what the product is. In this work, if you're the next driver up, you got to deliver it. They didn't enforce that. Could they have had that rule? They could have had that rule. A lot of transport companies do. Or hey, get this. What if this company was Anheuser-Busch? And your job isn't occasionally to transport alcohol, but your job is every day, 3 times a day to transport alcohol. Might this be difficult to accommodate? I would say you might not be qualified for this work, but none of that inquiry happened. So please, with all due respect, I expect more out of you. When someone says they can't do their job for religious beliefs, does that beg a hard question? May I ask why? Should we involve our counsel in this regard to address this concern? I think we should. She's like, no way. But you get the idea. Should we involve, HR and legal counsel in this process? But the bottom line for me is either you can do the job or not do the job. We have to accommodate you or not. What offended me about this is that kind of makes me mad that someone would try to engineer their own political purpose behind these cases. where they don't exist. You may feel as though the world is changing, but do these rules still hold true? They do to me. And I think this request is going to be made more frequently, and we have to know how to anticipate it, correct? Questions on that? So don't let anyone pull the wool over your eyes. It's not why we do this stuff. Which goes to the next one. Pregnant persons. This is an incredibly busy slide. I'm going to make sure I do justice to this topic in a relative short order, because here's how it goes. This slide's incredibly busy, and I'll tell you why. So I think this could happen in any workplace in America. So in the case Ms. Young, she shows up, she works for UPS, she's a driver. UPS drivers, if you're unfamiliar, in their job description says they have to be able to deliver packages weighing up to 70 pounds, which I got to tell you, 70 pounds is a lot of weight to deliver in one package. So you have to be able to deliver packages weighing up to 70 pounds. She notifies her manager that she has become pregnant, and therefore she asks for an accommodation, not have to lift packages weighing that much. She can still deliver packages, but she has a weight limit from her doctor that is substantially less than 70 pounds. So she asked for a temporary modification of work duties, and ironically, here's the thing that's really important for you and really important for this case. UPS had jobs that they had preserved for people who fell into categories where they couldn't do their job. And these aren't going to surprise you. People who are disabled under the ADA got accommodations. People who'd lost their DOT driving certification and couldn't drive for a while because they're on medications, they got accommodated. So a temporary driver, temporarily unable to drive, and they wouldn't give her one. Does this already sound like a problem? Yeah, this case is already, she's batting, she's improving her batting average because they've been accommodating people but not pregnant employees. And so here's the news. This case actually is going to change the workplace to some degree. Supreme Court fashioned a new test to determine whether pregnancy discrimination exists. And the test is really at the bottom there, is what you need to know, is that you don't have to show the traditional test for showing discrimination. All you have to show is your request for pregnancy accommodation was denied, and this decision has an adverse or significant impact, is the word that they use, significant impact on pregnant workers. So here's the bottom line for us. You don't need to know any law on this. Can any pregnant employee ask for an accommodation in her job? Does the burden then shift to you to demonstrate that it does or does not have a significant impact on pregnant workers? So you're going to be under some pressure to determine what have you done for other employees with short-term medical conditions, and why can't you do it for a pregnant employee? I got to tell you, there's police officers in the room. Is that going to be a big deal for you? If you've accommodated other patrol officers, are you going to have to accommodate potentially the pregnant employee if they're still qualified to do their job? Does that make sense? That's a big deal. The case has some good news, though, because ironically, the Supreme Court threw out the EEOC. The EEOC got beat up last year, something fierce. Besides that religion case, they basically lost nearly every other case in which they faced some scrutiny. But they had these guidelines in 2014 about pregnancy discrimination, and basically those guidelines gave pregnancy, I use the term most favored nation status, that regardless of all the protections of our civil rights laws, the EEOC guidelines gave pregnancy a heightened protection. You must accommodate pregnancy akin to the ADA. And the federal government, Supreme Court said, that's too much. Do you still have to consider modifications of jobs for pregnant workers? Do you have to consider the impact on pregnant workers of not accommodating them? Those are going to be critical, but those 2014 guidelines are simply too much in the protective area. So what they come up with as a result of this, they gave new guidelines out. Talk about this relatively quickly. So how do we manage employees who are pregnant in the workplace? It's pretty straightforward, and these guidelines help us out a lot. First thing you got to know is this. Do we have to consider accommodations of pregnant workers if you've accommodated other people in same or similar positions? Yes, you got to do that. If you've accommodated people who are in similarly situated jobs, you got to consider the same accommodation for a pregnant worker. Secondarily, can you treat a pregnant worker favorably? Yes. Many doctors tell me, and my wife's gone through this process 3 times, that the period up to 6, 8, possibly 12 weeks following the birth of a child, the mother may be physically incapacitated from doing many work functions. Therefore, can we treat that mother's medical status different than a new father's rights? You're allowed to treat new mom with medical limitations differently than new dad. So I'm not trying to be disparaging here, but could you say something like this? New mom's going to get a pregnancy benefit following the birth of the child. New dads, we're going to limit you to 2 weeks paid parental leave. Could you do that? You're allowed to distinguish the medical condition of birth from the child bonding rights or benefits you give your employees. This case does not address really the wild card for me that you're probably thinking about. What about adoptive parents? It's not a medical condition for the new mom, and nothing under federal law addresses that particular issue. But I will tell you, if you're an adoptive parent, Colorado's got a state statute that says you have to give newly adoptive parents the same rights and benefits in the workplace you give biological parents. So you're going to have to consider giving a new mom or a new dad from an adoptive family similar benefits for parental leave. Yeah, which makes sense, right? Questions on pregnancy. Hyperprotected. I'll also tell you what these guidelines tell us. Please avoid overt paternalism. Making decisions about a pregnant worker without adequate medical basis. For example, where employers violate these rules, if you have a physically demanding job, they work in the rec center, they have life-saving responsibilities, or they work in law enforcement, or they work in parks where they're operating heavy equipment or machinery. Please avoid paternalism. It's illegal to say, "Oh, little lady, I don't think you should be doing this at 6 months." That's going to get the federal government immediately on your doorstep. If you really thought someone couldn't do their job because they're pregnant, what's the appropriate thing to do? You need to go to your doctor with a copy of your job description and let me know what limitations you have. Can you inquire? If the job has physical demands, can you make that inquiry? Always. That's the right thing to do, is here's your job description, take it to your doctor. We want to make sure you're able to do this job function during the course of your pregnancy. And you probably realize, do most employees continue to work during their entire pregnancy? They often do. Questions on that? Okay, you guys are all over this stuff. All right. Same-sex marriage is a lawful right. I don't have to talk about this very much. It's obviously front-page news. Most people have an understanding of this. I do want to make one thing clear. If same-sex marriage, remember, when our Supreme Court rules, it's the law of the land. Whether you agree or disagree, is this now the law of the land? It is. Under the Equal Protection Clause of the Constitution and the 14th Amendment, what I want you to think about is 2 questions. And again, this is an HR question, not a management question. So HR is already all over this. The 2 questions that come up is, have we now incorporated same-sex marriage partners into the scope of our benefits? And the second question is, if we had domestic partner benefits, many employers, prior to this decision, had already started domestic partner benefits at respective workplaces. The question now is, should we still have domestic partner benefits now that same-sex marriages are the law of the land? So many of my employers are pulling away from domestic partner benefits and putting all these benefits in terms of marital benefits. So that's the only 2 questions that come up from this particular decision. Questions on the right to 2 persons of the same sex to be married? I think most people have a full understanding of it. It's been since June 26th. I think people get that benefit. But I will tell you one thing about the federal government, and this is important. The federal government believes that sexual orientation is protected under the gender protection of Title VII. Please, this is not, I know you know this already. Colorado law protects employees based on their sexual orientation. You all know that. You can't discriminate or harass somebody based on the fact they're heterosexual, homosexual, or bisexual. Federal law does not protect sexual orientation. However, the Equal Employment Opportunity Commission believes that sexual orientation is an aspect of one's gender, and therefore they are enforcing the Civil Rights Act of 1964 based exclusively on sexual orientation discrimination. The example I give is this Baldwin case up here. Employee was not selected for promotion allegedly solely because he's gay. Didn't get the job because he's gay. That's entirely based on what? Not your gender, but your sexual orientation. You didn't get the job because you're gay. Not because you're a man, but because you're gay. The federal administrative judge here found that that was a form of gender discrimination in the workplace and therefore unlawful. So is this a trend that you need to be aware of? Yeah, sexual orientation is protected at many levels. The more interesting question is the bottom bullet up there. Last year, the EEOC found that being transgender was a protection based on your sexual, on your gender. And so are transgender individuals also protected under Title VII according to the federal government? That is not the law. That is a matter of interpretation by the federal government. What does it mean to me? Transgender rights are already protected in Colorado, but these cases are coming fast and furiously. So let me run through them relatively quickly. OSHA came up with a restroom rule last year. You got to know it this year. What's the restroom rule? The restroom rule says this: not only do employees always have a right to access to a restroom, but in cases of gender identity, an employee has a right to access that workplace restroom to which they identify their gender, not what biological gender they have assigned to them at birth. Meaning this: if a biological male who identifies as female wants to use the restroom in the workplace, according to OSHA, the Occupational Safety and Health Administration, what would be their lawful right? The women's restroom. Now, for us in Colorado, this doesn't change existing law. That is the rule in Colorado. If you're unfamiliar, a transgender person has the right to use the restroom of their gender identity rather than their assigned biological gender at birth. So in the case of a biological male to female, she would have the right to use the women's restroom. Does that include over the objections of other female employees? It does. Please remember. Where these cases are getting dizzying, and I want to make you aware of this because you're going to hear more about it, the cases are getting interesting because of the litigation issues. In this case, if you see the last two bullets up there, is interestingly enough, trying to restrict a person's access to a restroom could be gender discrimination. And then finally, in the most interesting case of this year, a school district in Illinois held that it was a violation of Title IX. Remember, this is the gender discrimination protections for educational environments. Very similar to Title VII protects the workplace. A school district in Illinois, and this is a case that fascinates me, held that it was unlawful gender discrimination to prevent a student, a minor by the way, to prevent a student from accessing a biological male who identifies as female. It was unlawful to prevent her from using the women's locker room and changing area for physical fitness activities in a high school in Illinois under Title IX. That's not Colorado law. That's even the case, even though parents argued and the school district argued that to expose a minor child to a person of a different assigned biological gender who identifies as the opposite biological gender to a locker room encounter would be very difficult potentially for the persons in that locker room encounter. They said that was not sufficient reason to limit this person's use of school facilities. That is not the case in Colorado. You know the rule in Colorado is you have to reasonably accommodate a transgender person's use of changing rooms and locker room facilities. You can't necessarily bar entry, but could you make locker room facilities more private in the sense of person's use? I think this case right here has effectively ended the days of the gang shower, the open shower bay area of most changing facilities that people attend to in schools, in recreational facilities. And now what's the newfound construction that we're finding in these areas? Individual stalls with curtains or doors on each individual stall to allow people a measure of more privacy protection in a changing area or locker room. Just like we're seeing the advent of the unisex restroom, whereas any gender can use the restroom as long as there's a lock on the door to allow a measure of personal privacy. So are these rulings potentially changing the landscape by which people would engage in potential recreational activities? It's going to affect how rec centers address this issue.
Question. So with the transgender, we were just asking some questions. Does that individual have the right to use, for example, I don't know, say they dress up as a male, biological male, but chooses to be a female or transgender, but that day, say he comes to work and he's a male that day, he still can use the female restroom, or does he have to use the male restroom?
Could still use the female restroom, although this begs a difficult question in this area, and by far and away, the question I get asked most frequently, I've walked a lot of people through this transitioning process. The greatest difficulty in this area is in that period of transition where the person who is transitioning their gender identity does not conform regularly to the transition, meaning on some days they appear male, some days they appear female. That is not uncommon. I will tell you my advice on that. This begs for a dialogue between human resources and the individual to determine reasonably what we can expect as far as that person's gender identity, solely for their benefit and for the benefit of fellow employees, to ensure a reasonable transition. That is a hard human resources question when it's not, I'm going to say this, I don't mean to turn you off, and it's probably too much time to devote this conversation because it doesn't come up that frequently. But that said, most people understand this concept and most people are willing to understand the roots under it. Where it becomes difficult is this issue, where someone's not clear about their intentions, at least to the observer, and it makes it very hard for people to reconcile these rights. And so does that beg for human resources really to step up and have a dialogue with that individual to determine what we can reasonably expect? And does that allow coworkers to potentially much more readily address this issue? No one wants to get it wrong, right? But we also want to make sure we're not overstepping, rights in this area. Does that follow? So that is an awesome inquiry. Hey, can you guys take about 5 minutes? I want you to step away from this. We're still going to end before noon, but I want to make sure you get away from this for a little bit because it's kind of heady stuff and you're doing well and the questions are awesome. So take 5. Make sure you sign into our attendance sheet, but I want to make sure you're well prepared for our last part of our class. You good? Does anybody need a hug? All right. Thank you, brother.
So, patron comes in.
A patron comes in.
And they identify themselves and say up front to the front desk, identify myself as a female.
Yeah, it's a sad reality. If they heard the comment, it could potentially beg for abuse in which people actually use this to jump in and out of things. The question that comes up a lot is, I call it the Red Rocks problem. If you've ever been to Red Rocks for a concert, you probably realize you've had this experience. Because the women's restroom gets so crowded, women constantly jump into the men's restroom. I don't know if you've ever been to a concert there. And so I could easily see someone saying, a man saying, well, my gender identity says I got to use this restroom for one of expedience. And so could people potentially try to, misuse these rules? I think that's a rarity. And of course, we don't make rules for the one case. We make them for the broader population. And I'm worried about reaction to one instance in any case. But that could be room for abuse in this area. And that's come up a lot, especially with the access to the restroom, especially if you have underlying issues about the desire to be in a restroom. which is a whole nother issue, and you talked about it earlier. If you have some sexual gratification issue, how will we even manage that you need to be in a restroom? And so we still have to use our protocols in place and trust that people are going to identify sincerely this is their gender identity. That's why your comment was really great. The two questions that come up a lot is, how do we identify sincere gender expression if you're changing your gender constantly? And number two, the question that came up during the break is minors. At what age can people lawfully, truly assert their rights under these rules? Because to what extent, can you consciously identify your gender identity when you're under the age, when you're not an adult? So these are hard questions. Question?
I'm just wondering if this has been tested with all boys or all girls schools yet. I mean, it kind of goes beyond the restroom thing, but...
Well, interestingly enough, as far as all boys or all girls, recall that you're allowed, private organizations are allowed to engage in discrimination. And so they're often not subject to the scrutiny of the federal government because they're private membership organizations or private clubs or groups. For example, an all-boys Catholic school, religious organizations can discriminate in favor of their own religious beliefs or traditions. So a religious organization, a religious school, can segregate classrooms, can have a religious litmus test on their membership and people who go to those schools. That's lawful for them to do it. The Masters, what's the golf club? Augusta, private membership organization, could be free from federal government scrutiny because they're a private membership club or organization. They're not subject to these rules. So you can have an all-men's club, private membership club or school, an all-women's private membership club or school, and escape the government scrutiny of your business model or of your educational model in that regard. You're allowed to do it. That's an awesome question. So some discrimination in the United States is still lawful because it's excluded from the government's purview. Let's keep going. All right, security check, not work time. I love this case. I got two of them in a row. This is a great case for employers who have any type of monitoring of their employees. This is the case that came up in front of the U.S. Supreme Court. Amazon employees, as they walk out of the building at the end of the day, had to go through a security screening. Why? What's the concern? Grabby with the products. They're in a warehouse. Have you seen these Amazon warehouses that they have? They're gigantic. They're monstrously huge. And so people have access to a variety of equipment or property, much of it of value. And so employees go through a screening. Employees argued, wait a minute, I was off work. I should get paid for that security screening. Supreme Court says, no, that's not an integral part of your job. Therefore, it's not compensable work time. Interestingly enough, California even upheld this. California, which you all know is what? The most employee-friendly jurisdiction in America. In this case, Apple employees could be searched. That additional time did not constitute work time. Of course, Apple products, you probably realize these, are tremendously subject to theft. Their value in the open market is very high. Apple stores get robbed all the time because of the value of their products. They're small and you can move a lot of them and they have value. And so can you search our employees? You know why I really like these cases? Because they demonstrate that can we put employees under reasonable security protocols? Yeah, and is that becoming more of a concern in the age of safety, in the age of workplace violence? So I put this in here to make you think. If people need to go through a security matrix to get to and from buildings, is that going to be part of their job perhaps? And you're not going to get paid more for it. I will tell you, though, how can employers avoid these cases? I still think it would have been just as easy to check their bag as they're walking to their time recording system. If there is why would, instead of setting up the check on the other end of the time card system, why wouldn't you set it up on the front end and say, you got to walk through this to get to the time card, let me see your bag, open up your stuff? Or could you direct employees to do what? Can't bring your stuff here. You can't bring bags into our facility. Leave it in your car. You can go out to the car during the day if you need something out of your bag. And could you also have that rule? So you don't have a right to bring a bag into the workplace. The only issue there would be if you have a disability, going back to your awesome point, you have a disability and that carries your oxygen tank, would you have a right to bring that bag in? Very good. Now you put it all together, right, is that you got to still accommodate those disabilities. Questions on that? I like these two cases, though. That's the future of work, much more scrutiny, correct? So please keep that in mind. Telecommuting, good news on this. Having a telecommuting policy alone doesn't give employees the right to work from home, and that's important to distinguish. Having a telecommuting policy that authorizes or allows employee to work from home doesn't mean you have the guarantee of the right to work from home. It's usually controlled by whom? The employer who allows it. This Ford case up here is fascinating to me. It was the big case of the last year in which employee with irritable bowel syndrome, it's often associated with Crohn's disease, tremendously difficult, if any of you know anybody with this disease, very difficult to live your life if you have a heightened case of Crohn's or irritable bowel, constantly have to go to the bathroom, therefore it begs for accommodations, correct? So this employee says, and they have a telecommuting policy that says you can work from home 1 day a week. She asked for 4 days a week working from home. Employer says, too much. You have to meet our clients. You have to interact with your supervisor. That's simply too much. We can't accommodate that. And instead, because you have a difficulty, we'll give you the workspace which is by far the closest to the bathroom. Which the employee actually took as an insult, is I have to sit by the bathroom. And so the employer's take was, this is intended to attempt to accommodate you. You have frequent restroom breaks. We'll make this trip as easy on you and the organization as possible. So the employee sues failure to accommodate. You wouldn't accommodate my request to work from home when you allow other employees to work from home. And remember how the ADA works? What you do for other employees, you have to consider doing for this employee as an accommodation. But the Equal Employment Opportunity Commissions got, once again, spanked because allowing people under a telecommuting policy to work from home 1 day a week in no way is the same as working from home 4 days a week. And so here, having a telecommuting policy actually helped because it articulated what the reasonable basis was for working at home. And these cases are easy for employers to win because all the supervisor has to come up and say is what? Job requires you to be here. We're in parks, and you know what we service? The parks of the facility, of the community, and therefore you're required to be here. Or my job requires me to interact with patrons or members of the public, where I have to do that where? Here. Or the job requires supervision. We exchange instructions back and forth during the day, and so is reasonable periods of interaction with your boss part of everyone's job? This makes sense? I would want to make it clear after reading these cases, though, is this a pretty common request of employees to work from home? And you know who really wants to work from home? We're not feeling the love here, perhaps. And so this may be a constant request if there's an underlying management issue associated with that particular employee. So would you please be prepared for it by doing two things? Number one, knowing your job description of your employees, in which it's very clear that their job dictates that they have to do some of the functions of their job here. And secondarily, while it's always okay to accommodate people who need to take some time away from work, can we reasonably put a limit on that if you're required to supervise them? So being the absentee landlord, the supervisor who doesn't interact with their employees, are you effectively hurting yourself in this regard? So you got to keep tabs on the people you work with, right? Does that make sense? Questions on that? I love this case. They all go for the employer, which goes to disability is broad. You got to know it. This gets in the human resources realm. Can any employee in America say they're disabled and request accommodation? Linda's like, absolutely. Because, and she's alluded to it, is some disabilities are not visible to the naked eye, if you will. Can psychological impairments be disabling conditions? I love this case for one reason. This employee has social anxiety disorder. And she argues that a product of her disability is she has difficult interactions with members of the public. Now, you know when the employer found out about this disability? When she was hired for a clerk position within her organization, and of the 35 clerks they have, 5 of them are selected to do direct customer service. And she was selected to do direct customer service. So mind you, 35 of your colleagues are behind the building with little or no interaction with other people, and 5 people have the more, I will say, demanding job. If you're a people person, you probably love this. But if you're not a people person, you might not. And so she's one of the 5 people at the front of the public sector workplace. She doesn't like it. So she advises them. She has social anxiety disorder. So here's the question. If 30 of your coworkers have the ability to work away from this, and 5 have to do it, do you think there's some room for compromise here, for accommodation? I would argue yes. Is that could they have a rotation in which people cycle in and out of the customer service function? Could people time away from this front desk position? Because you realize the bottom line on the story, is that the difficult job, dealing with members of the public? On some level, that's where you're the tip of the spear, right? You've all felt that here with people in some of your jobs. They're going to be very difficult to interact with. So please be mindful. This is important. I see this request made a lot. I have difficulty working with members of the public. And if your narrative is, well, we all work with members of the public, you might be accused of failing to accommodate. So please cycle these requests over to HR. Doug? Conceivably, they could have changed the job description. Front desk clerk with analyst, or they could have changed the nature. They didn't do that. They had 35 jobs, and they basically plucked 5 people to do the front part of this. And it's basically like a public records job in which the 5 people, like in my local county, where you cycle through this, some people are at the front desk, and then some people back, and they move people to the front and back, because it's very difficult to issue license plates with people who are really angry, things along those lines. Other issue, question, sir?
I guess a similar question is that it was in the job description that part of the responsibility when you're interacting with the public, then the obligation or the responsibility is on all clerks, knowing they're going to have to fill that role, and they have to fill that role.
Yeah, I love this. This is the golden nuggets that come into these classes. And of course, there's always some bright line rules here. Number 1, you never have to take away essential functions of the job as an accommodation. If the job required the ability to interact with the public, and it was an essential function of the job, would this person potentially be disqualified from working there? That would have to be articulated as an essential function of the job, and you, supervisor, would have to be able to establish that, because it could be challenged. But do many jobs in public sector work require ability to interact with the public? They really do. So not everybody. She had the benefit of the fact that 30 of her peers never had to interact with the public, which suggests it's not essential. That's a great point. Going to your point, Doug, maybe a different job could exist in which we would articulate this. Secondarily, remember our protocols here. If someone says they physically or mentally cannot do their job, what do? We follow a script. Thank you so much for coming to me. You should practice it with me. Thank you so much for coming to me. I care about you. I know I reek of insincerity here, but it's important that you hear this. Thank you so much. I care about you. Please contact Human Resources, where they're going to give you a copy of your job description, and ask your medical provider to determine what limitations, if any, you have in doing your job. That's the protocol at Commerce City. It's effective. You're successful in this regard. Go to HR. You need to take your job description to your medical provider and let us know not how many kinds of crazy you are, but what limitations, if any, you have in doing your job. And there's a functional difference under the ADA. Does that make sense? And you do that here. So remember, it's not a challenge in this organization when someone says they can't do their job. It's the beginning of a dialogue or a process. I will also tell you, I loved your question. Love your question. This is probably why we have this class, and I always talk out of turn. But I will tell you, I have strong feelings about this. When you tell me you can't do your job, as your boss, and I'm not trying to be mean about this, what has to be percolating through my head? If you say you can't do part of your job, and your job's super important, like it's in the police department, what's percolating through my head as your boss? Is this really a job that you're qualified for? Is that a reasonable question for us to ask? And I want to make sure you know this, because we're doing 1 million classes in 2 hours. What 3 things does Commerce City never have to accommodate under the ADA? Number one, someone who is a direct threat to the health or safety of others. You're going to see that come up in 1 second. Someone's a direct threat to the health and safety of themselves or others. I get that with suicidal ideations all the time. I'd like to kill myself. Reasonable people could say, this job is causing you to potentially be disqualified from working here. You're a threat to yourself or others. Or the fact you want to kill a coworker or another person would also disqualify you. Don't have to accommodate that. I don't have to accommodate somebody who would be an undue hardship to accommodate. Simply too hard, too expensive. And that's a calculus of the total cost of the accommodation versus our budget. That's a tougher nut to crack. You're a relatively large municipality. Might you have to expend some funds to accommodate? But you know what is often lost on the ADA? You don't have to accommodate somebody who's no longer qualified for their job. You have to consider reassignment, which is a form of accommodation. But if you're no longer qualified for your job, the accommodation process is relatively abrupt. Either you do your job or another job that it's available for you, you could potentially do. Does that make sense? So you got to know that. So when people say, I can't do my job, we kind of immediately channel them to HR to ask that inquiry. Because when you ask it, what does it look like? You're a discriminator. You're a harasser. Awesome. You get the drift on this. You can't say, how weird are you? What kind of crazy do you have going on? That looks like I have a beef about people who may have underlying psychological deficits, and we don't do that. You're thinking it, but you don't do it publicly. You use your little voice, your inside voice. You don't use your big voice. That's where people get sued. And, people of provocative opinions get sued all the time because they open their mouth when they shouldn't. Use your inside head voice. It's super quiet. You're so weird. Nobody likes you and nobody wants you here. Can you hear that right now? I hope not. Okay, you get the idea. All right, let's keep going. No need to accommodate violence. Okay, for a moment of seriousness, I'm really struggling with this workplace violence epidemic and what we can do about it, but one thing I want to give you a gift. When people say or threaten their coworkers, are they potentially disqualified from working in their workplace in the United States in a post-Columbine, post-San Bernardino County world? This is disturbing news to those people who cannot engage in impulse control. Now, I'm with you. If someone says, I have impulse control disorder and I like to go off on people I work with, and they haven't done it yet, might we have to consider accommodations? But if they go off on their coworker, is that potentially the form of violence that we can disqualify them from employment? These cases are amazing. In this case, this guy threatens his supervisor. I put this case in here because I love the quote from the court. I think this is an amazing, true statement from the judge. Are there people who are actively targeting their coworkers? And what reasonably do we have to accommodate that for? That makes no sense under any legal regime. So please remember this quote. It would be unrealistic for us to have to take the first hit from someone who reasonably was engaging behavior that's unacceptable. I struggle with here, though, are there people who still haven't gotten the message on this? If you know people who are really provocative in this regard, it sounds terrible to say this, but I get that sort of, I'll call it old school, people who are so upset that they act out aggressively, and these people are going to get fired with increasing frequency, which may on some level escalate a problem. But if you say to somebody, I want to knock your head off the top of your body, even if I'm just being passionate, are you going to lose your job? You're going to lose it. I mean, I know a whole generation of people my age, that's how they verbally interact. I ought to kick your rear end from here to Sunday, which is a long way. It's only Tuesday. And so you get the idea, is that a potential problem at work? And so I worry about this. People who have that mentality have really now become a liability in the organization. It's sad to say that. All I have to do, I just imagine my kids are getting in the workplace now. They have no place for that. Hey, I don't go to work here to get threatened. I was raised in a high school in America where we were taught from grade kindergarten that we out bullies, and you're a bully, and therefore I don't have to work with you anymore. My mom and dad told me that, and so did my school administrators. And so HR should think the same way. And so you get the idea is that person who is aggressive, it really needs to work on some coping mechanisms to deal with this aggressor behavior. because they're going to lose their job. Please spread the word on that if you know people who have that personality, who really get frustrated quickly, who don't have outlets for their aggression, and potentially have that, I call it big man talk. The like, hey, I'm the toughest person in the room. You should know it. Let me convince you every day of the rest of your life. Right. I know you're the toughest guy in our organization. Thank you so much for intimidating me every day. Got it. Is that eventually going to reach a point of crisis that someone's going to grow weary of it? And they're probably going to jettison that person from the workplace. While I can tolerate that kind of discussion, fewer and fewer people can. So please remember that. Okay. Do we have to address workplace violence? Hey, do you guys have a threat assessment team? You have a threat assessment team? You got to think about it now. I can't make you do anything, but that's now the trend is having a threat assessment team internal. So not after threats happen, we immediately use our law enforcement for our own threats in our organization, but and we want to make sure, and they're well trained to do that, we want to be able to assess threats that manifest themselves before violence culminates. And so a threat assessment team is often legal, is often law enforcement, is often a psychologist trained to identify threats, is often human resources representative, often risk manager, and often a city official who has some high-level authority to address these concerns. You might want to consider doing that. That's become the trend of late. I was on a number of these threat assessment teams. They're quite helpful, especially to get the input of a psychologist who is trained in the dynamics of violence as it progresses. Not every human being has that skill set. Questions on that? Next one, off-the-clock work and the Fair Labor Standards Act. I'm just going to get this off my chest quickly. I'm going to preach to you. These cases are becoming more and more frequent where employees are asking to be paid for work from home off the clock. Are you familiar with this? And you know what's created this? I don't know if I brought my phone. But when you give somebody a phone or a PDA, do they have access to work-related tools when they're home? And so employers are getting pummeled by this because they were unprepared for it. So let me tell you our defense to this. Our defense is having policies in place that basically say this. Number one, you can't work without authorization. You can't work overtime without authorization. Number two, you have to record all work hours during any given week, and your failure to record work hours is a violation of our rules. And number three, there has to be a protocol in place if you have incorrectly reported your work hours. This is the mode for correcting work hours deficiencies or errors. That gives people like me the ability to ask this question. When someone says a year later, I worked every night by candlelight for 8 hours a night working for the benefit of Commerce City, I get to say, you didn't put it down in your time card. We had a mechanism in place you're putting down in your time card. Reasonable people could believe you violated our own rules. You didn't work this time. And so does that push off these complaints? Were you lying then or are you lying now is basically my defense. I'm not trying to be disparaging, but look, if you're working hours, you got to write it down. You know what screws those cases up though? This case, where the supervisor says, rules be damned. You're going to work at home until I tell you don't have to work at home. And quite frankly, don't write down that overtime stuff anyway. I can't pay you for it. Does that give the employee carte blanche to get paid for those hours? So you know why you're in this class? If you have those rules that demand overtime, you're the ones who are charged with enforcing it, not your HR department, not your legal department. That's you who have to enforce this. So if you hear people are working from home, I need to have that written down so I can manage it. I need to pay you or give you compensatory time off for doing this, or manage your schedule to compensate you for that time. But no one should get away with working off the clock on your watch. Does that make sense? And if you learn employers are doing it, you got to ask them the hard question. What the heck are you doing at night that you can't get done during the day? Well, I'm answering your emails. Oh. That suggests that you're expecting them to do it and maybe not be compensated for it. So what does the high-minded supervisor do? I expect you to be paid for that, or I expect you to take an hour off tomorrow to compensate you for it today. Would that all be reasonable on your part if you're compelling that work at night? But if they're working of their own volition, I would encourage you to tell people they can't do it unless you expect it.
Is there any case law revolving around exempt or non-overtime eligible employees? How these rules apply?
Yes. Well, exempt employees we can work to death. I mean, it's basically all the case authority is, if you're an exempt employee, and many of you are exempt employees, could I call you at all hours? What are you doing? Are you thinking about work tomorrow? I am. I know, it's fun, isn't it? Yeah. Oh, are you going to go to bed? No, let's talk about work. Hey, let's role play. That's every employee's favorite thing. Let's role play the meeting tomorrow. Yeah, okay. If you're exempt, I could literally work you 24/7, 365. You know, if you're in the room, you're exempt. You know that feeling already. But if you're non-exempt is where these rules trigger, and that's a big deal. Now, I'm going to mention a couple things about this. Please keep in mind, if employees want to opt out of time recording systems, we require them to do so for religious beliefs. Do we have to accommodate it? Yeah, this is my favorite case of the last year. It's the Mark of the Beast case, if you're familiar with it. The Mark of the Beast case is where the employee, West Virginia, so it already is all you need to know about this case. Employee at a West Virginia workplace says the employer adopts a hand scanning device as their attendance metric. So it's basically a biometric tool, reads your fingerprints and your hand scan, and that's how you record your entry and exit out of the building. And it's a good mechanism instead of a time clock, because it immediately goes into a computer-generated time reporting tool. And the employee says, "I'm not using that biometric device because it's the mark of the beast." I added the accent just because it just adds a flavor. It's West Virginia. Here, I love this case. I love this case. I'm writing an article about it because the case is awesome. First, the employer, instead of saying, "Well, that's ridiculous, but let's look for alternatives," which they had, by the way, been giving people who couldn't use this device because they didn't have a hand or some other accommodation. So they allowed them to use traditional time recording systems like a time card. But interestingly enough, so they've been accommodating people, which is why they lost this case. But the employer, I love this case, instead of saying, "What can I do to help you?" they hire a local minister to give them a theological opinion that hand scanning devices are literally, according to the book of Revelations in the New Testament in the Bible, are not actually the mark of the beast. And who would better know that than a minister in West Virginia? And so they kind of went all lawyerly. So they got theologians involved to say this hand scanning device. In fact, the company had actually vetted this because a lot of people had registered this religious objection. So they hired their own theologian to make it very clear, "Oh no, there are many things that are the mark of the beast, but this is not one." Those UPC scan barcodes, now that's a problem. But this bad boy, this is devil protected. Just so you know. And so you get the idea. So do you have to accommodate people who desire to opt out? You know that already, correct? Which goes to a few things that are relatively quick. Oh, we're good on time. So wellness programs. Do you guys have a wellness program? I didn't ask. Yeah, wellness programs are under huge scrutiny because of, number one, they have to be voluntary, and number two, it's the access to the information that we collect. So the federal government's chimed in with HIPAA rules, with Genetic Information Non-Discrimination Act protection rules, with ADA rules, basically to ensure that you don't violate somebody's rights. Can you have a wellness program? Yes, thank God. But they're very closely monitored by the federal government. HR has that functional responsibility to address that. Next one, Supreme Court cases I'm not going to talk about. The first one is that conciliation case that I mentioned earlier. The second one was, you probably heard about it, King versus Burwell. That was, I think, the 10th effort in the federal courts to try to kill the Affordable Care Act, so-called Obamacare, and yet again was unsuccessful to the Supreme Court. So no end to the Affordable Care Act in the last court look at this. There's still actually another case percolating its way through the courts involving the Affordable Care Act. You'll see that at the very end of this, a Supreme Court case. A number of religious, you made me think about it with the religious issue earlier. A number of religious institutions are challenging the contraceptive care provision of the Affordable Care Act. That case is going to be heard this term. You might have heard about it. The Little Sisters of the Poor mandated to have contraceptive care coverage over their religious objection. That case is making its way through the courts right now. A number of religious nonprofits have brought that case. That's an interesting case, actually. It's also an interesting enforcement question because contraceptive care is covered under gender protection, which is a protection, but this is an expression of religious freedom. So it's a case in which two protections literally collide, and the Supreme Court's got to decipher that. So it's fascinating on a societal level. Next one is e-cigarettes and vaping. Hey, please keep in mind, you don't have a right to use these devices in the workplace, but you do have a right to use e-cigarettes and vaping devices outside of the workplace. Smoking lawful products is protected in Colorado off-duty and off-premises. But could we treat e-cigarettes and vaping similar that we do under our no smoking policy? So the bottom line, HR already knows this, but you need to hear it, is there is a move afoot to put these devices under a no smoking policy in workplaces. Because are some employees concerned, well, I think this does potentially reduce or allow people to quit smoking by using these devices. Are some employees concerned that being proximate to e-cigarettes and vaping devices, it's unknown what the secondhand health consequences of that are, so they're concerned about being proximate to these devices. Make sense? Next one is guns at work. Oh my gosh, I could talk about this for the rest of our class. This is a hugely hot topic. I want to make a couple things very clear about this. In Colorado, this is a relatively sparse area of workplace law. There's not a lot to hang your hat on for organizations, but let me give you the rules so you know them. I know a lot of you know the rules already, and law enforcement already knows all these rules, but let me just mention how it works for us. It goes like this, and I'll tell you what prompted this. I'm getting questions every day from employees. Can I say this without causing embarrassment? I'm getting questions from employees every day about wanting to bring a gun to work. I get that question a lot. And so it really raises the specter of our ability to address this issue. Now, I also have to tell you, does that raise the concerns of people who have coworkers with guns at work? And, thankfully, you already have a dedicated law enforcement agency in which you have authorized weapons in the workplace. So let me give you the rule, and it goes something like this. Open and concealed carry. Our Colorado state constitution allows for individual right to bear arms. So according to the U.S. Supreme Court, does the federal law under the Second Amendment allows for an individual right to bear arms. Here's the restriction. Our Colorado courts have not addressed open carry in any great detail other than to say this. Public sector employers can ban open carry at public places. So can we post no open carry at all of our facilities and keep people from open carrying on the premises? The answer is yes. You're allowed to do that. Many municipal entities do it. They prohibit open carry at their public places. The harder question by far is concealed carry. I gave you the rules up there. Once somebody has concealed carry, you have the right to carry concealed, assuming you are authorized and properly permitted to do so. At all these places, every place except these that are listed, and they include places the federal law dictates, school district property. Generally, there's a bunch of exceptions to that, but generally, K through 12 institutions, you can keep a gun off the premises, generally in that regard. And of course, the big one is public buildings have screening devices at each public entrance with appropriate security personnel. These have to be literal gun-free zones in which you attempt to secure access to the premises using screening devices. So could we keep open and concealed carry off of our premises if we made the effort to do so? You're allowed to do so. Denver being the principal example of this. To enter most Denver facilities, you have to navigate your way through this type of screening procedure, and that's an effort to enforce Colorado's 2003 gun laws in this regard. They actually have a substantially more restrictive gun rule in Denver than other jurisdictions have. Here's the thing I want you to know. If we have a policy that says our employees can't bring guns on the premises, can we enforce that policy? My answer to that is yes. Now, I will say that because there are premises, correct? And we can generally regulate our employees. So can we limit carry to people who are authorized to carry within the organization? I will tell you why I'm raising this question. This issue has never been litigated. I want you to know that. I have no idea what the future, but what do I expect? Got litigated up in Boulder involving the CU campus, in which they said you couldn't limit concealed carry after you reached past grade 12 at campus environments. That presumptively would include employees of the University of Colorado at Boulder. So please be mindful of this. I happen to personally, right now, appreciate organizational policies that restrict carry to people who are properly authorized to carry, but could an employee try to argue and accept their own right to concealed carry? And all I'm saying is this. If you learn an employee is concealed carry, would you please address that with your own legal counsel about what the... Yeah, please. It would be hugely important for us to do that. It's becoming a difficulty for us to reconcile this, and we want to get it right. We want to make sure we don't infringe somebody's Second Amendment and Colorado constitutional rights, but we still don't enforce the City of Commerce City's ability to regulate its own workplace. Does that make sense? So don't overact here. But if you learn somebody is carrying a weapon, especially on the premises, having them in your car is a little bit harder to obviously enforce because we're not in the business typically of searching cars in the parking lot. But having them on their person in a concealed fashion does beg for human resources and legal consideration. Make sense? It's going to happen. I get it all the time now. So-and-so's got a gun. And it really raises concern among employees when they discover this. Is it becoming more common after the events of the last 2 weeks here? It is. Please know that. Off-the-clock work, I told, was going to be a bigger topic this year, so I want you to see that. The Department of Labor is going out there to make new rules about this. Stand by. We're going to get more regulatory guidance from them. Last couple is change to exempt status. I want to talk a little bit about this. So here's the new rule, and I want you to hear about it because I have no idea what the life of this is going to be. But it goes something like this. And thanks to Doug's question earlier, the world of employment is divided into exempt employees and non or not exempt employees. Exempt employees do not get overtime, are not entitled to overtime. There's no restriction on actually paying it to them, but they're not entitled to overtime. Non-exempt employees are entitled to overtime as a matter of law if they pass more than 40 hours in a work week. There's other exceptions that can change that rule. But that's the world of employment law. To be exempt, presently, today, to be exempt, you have to meet a three-part test. There's a bunch of exempt employees in the room. You know this already. But to be exempt, you have to meet a three-part test. Number one, you have to have exempt duties. The duties generally fall into three categories. You are either an executive, which is a manager, an administrator, even if you don't supervise anyone, you use independent discretion and judgment to make decisions for the benefit of Commerce City. That's a ton of people in this room. Or alternatively, you're a professional. You have an engineering degree, a law degree, you're a teacher, you're a graphic artist, you use the artistic professions. So those three categories of exempt duties render you potentially exempt. The second test, you got to get paid a salary to be exempt. Third test is where all the action is. In 2004, now more than 10 years ago, they made the threshold salary level $23,660 a year. If you made $23,660 a year or more, and you had those exempt duties, you were exempt from overtime. You can always challenge the exemption, but you're presumptively exempt from overtime. Here's the big news. With rulemaking authority, the Obama administration, through the Department of Labor, has raised that threshold salary level more than double to $50,440 a year in 2016. That is a lot of money, for anybody. And so it's really going to impact who's exempt and who's non-exempt in the organization. I recommend not going crazy on this right now. The big talk of the town is, when is this going to be implemented, if ever? And is it going to be implemented at $50,440 a year? So the positions are these. Number one is, according to the Department of Labor, even if they do it the way they want to do it, it's probably going to happen next summer. So don't make any changes on January 1st. Probably next summer. However, it's a contentious issue. The Department of Labor recognizes it's a contentious issue. They got 300,000 comments to the Department of Labor, which said this is unacceptable. We're in the metro area. But imagine in a rural community where salaries are substantially less than they are in a metro area. Would this affect a lot of people who have really important jobs? And so there's a move afoot to potentially lower that threshold down to a substantially lower number, which might be easier for people to administratively handle. And I will tell you, the third position is, it's a hugely contentious issue. Next year, if you haven't gotten the memo yet, is an election year. And might all of this go away in the midst of a contentious campaign season because people might try to make hay with it when it comes to a political campaign season. So could it die on the administrative vine potentially? I don't think that's necessarily likely. So you got to know that. So please stand by. More to follow on that. If you're exempt and you don't make $50,440 a year, though, might you get a pay raise? Yeah, conceivably, yes. All right, last couple. You know medical marijuana, 6-0. Can we regulate it? Can we limit employees from off-duty, off-premises medical marijuana use and still hold it against them on their job? Yeah, that's new Supreme Court Colorado decision from this year. Everybody read about that in the newspaper because you already knew that's not a lawful use under federal law. Therefore, think the same rule probably applies for recreational marijuana? Likely yes, given this precedent. Could we hold your recreational marijuana use against you? Next one, nearly everybody's an employee. I don't know how many independent contractors the city of Commerce City has, but the Department of Labor and the Internal Revenue Service are of the opinion anybody who does work for the benefit of Commerce City is presumptively an employee. If you have an independent contractor, you have to prove they're independent of you. Economically independent of you. So please, if you use independent contractors, we need to review those master service agreements with your contractors to prove that they're not literally living off of you as their sole form of business model, because that might be viewed as they're really a captive employee of your organization. Last couple. HIPAA is a big deal. Just so you know, Denver Pharmacy got tagged with a big loss. I love this. They basically did not manage their own documents. They kept a bunch of patient records open. That concerns me. You realize that these medical records also a prime source of identity theft? And so HIPAA's big, just so you know. Last couple of these are dogs and cats. I put a couple things in here for your consumption. Thankfully, you're not a private sector employer, because the next 3 slides are the additional regulatory requirements of private sector employers. You're not covered by the National Labor Relations Act, and thankfully you are not, because provisions are coming under review. Social media policies are coming under review. So I wanted you to see those 3 just to see them. I close by telling you this. Vacation. Use it or lose it policies are always subject to close scrutiny. I haven't looked at your policy in a while, but please keep in mind, under Colorado law, if an employee earns their vacation, if they earn it, do they have to be paid out vacation on termination? However, Colorado state law in this regard does not apply to public sector employers. But the Federal Fair Labor Standards Act has been interpreted in the same way. If you earn it, you have to pay out vacation. So please remember that. If you earn your vacation, you have to pay it out. What about sick leave? Not required to be paid out at termination if you calculate that as a benefit. Last couple. No more parental leave for academic activities. I wanted you to see this. So in 2009, they had a provision of Colorado law that said non-supervisory employees who are parents of K through 12 children could take up to 18 hours off a year to engage in academic activities for their child. That law was sunsetted in September, so there is no longer a lawful entitlement for employees to attend to academic activities. If your employees want to attend to their child's academic activities, what are they going to have to use? Their leave to do that, with their supervisor's approval. And the last thing, U.S. Supreme Court cases, I just thought I'd throw those out there. The only one that's really a big deal for a public sector employer is the first one. I wanted you to know that, is a police officer, this is actually one of these public sector employees' First Amendment cases. It's an awesome case. Police officer gets demoted because his mom had a campaign sign for the opponent on the police on her front yard. And so the question of what is the extent of a public sector employee's free speech rights is going to be addressed by the Supreme Court. I love these cases because public sector employees want to know that stuff. Could I get fired for having a yard sign in my front yard? Generally, no. You can't. But the question there is, what's the extent of this protection as far as your free speech rights? So I thought you'd want to see that. Last one is employees who want to resign and then rescind their resignation. Do you have to be thoughtful about wanting to not rehire them? This case is a lesson learned. in this case, the employee resigns, and then she resigns and she gives a statement in a sexual harassment case. And they say to her, well, we'll take care of it. Thank you so much for participating. And she says, well, if you're going to take care of it, I want to come back to work. And they go, no. And then she argues that was retaliation for having participated in the investigation. So if someone actually was resigning because they were involved in a sexual harassment case, and now you're addressing it and they want to come back, do you have to consider letting them come back? Which is illogical to me. And then I think the last thing I have for you is social media. The question of the day is, this is actually a case involving the National Labor Relations Act, but it has public employer implications, is could you be sued for your social media content? What do you think? Can social media be sexual harassment? Yeah, this case is involving a situation where an employee, in this case up here, see that picture up there? That guy posted a selfie of him with this other employee's child. You can't know if you can see it, but a young man, a young child who's black, and he posted on his Facebook page. And this is what bugs me about Facebook, is that a bunch of his coworkers, in good humor, which is never good, posted a ton of derogatory comments about this kid. And actually the employer, upon discovery of it, fired him. And the no challenge on his part is, could you get fired for what you post on Facebook? You really could. And this guy, and this is a workplace behavior, and therefore he got fired for this post. And so interestingly enough, I notice it's not protected in the National Labor Relations Act, First Amendment, or Colorado's off-duty activities because it happened at work. So could you get fired for posting stupid things from a work location? And then, of course, I have a comment about emojis. Can emojis suggest harassment? Did you see the new intern? Could that be potentially, the more those emojis are expressive, could they demonstrate an unwelcome work environment? I'm not trying to be hypersensitive here, but would you please use your best judgment and encourage others to use their best judgment when it comes to work-related behavior? These are evolving areas of the law. All right, questions? You guys are awesome to do this every year. I get so excited about it, I'm probably crazy on some level. But thank you. If you have any questions, I'm going to be around for a while to answer those. Linda, any closing comments? Any closing comments from anybody, actually? All right, you guys, pleasure, as always, to see you. Hey, please, 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 Merry Christmas, Happy Holidays, whatever you celebrate it well, and enjoy the new year.